Debbie, good morning. My name is Terri Janke. I'm a Meriam and Wuthathi woman from Australia. I practice as a lawyer. I have a unique firm that practices in Indigenous cultural and intellectual property. The increase of interest in Indigenous knowledge and Indigenous cultural expression in all areas, including the arts, film, architecture, design. These are areas that we work with and enable our clients, both Indigenous and non-Indigenous people, to collaborate in ways that have mutual benefits. We use the True Tracks principles, and I'd like to share them with you. The first principle is respect. So it's recognising Article 31 of the Declaration of the Rights of Indigenous People, the United Nations Declaration of the Rights of Indigenous People, and it's recognising that Indigenous people have the right to own, maintain and control their cultural heritage, traditional knowledge and traditional cultural expression. So when you're engaging and dealing with Indigenous knowledge, might be of plants to make new medicines, or it might be art to do fashion design, you must acknowledge that it comes from a source, Indigenous people. So engage with them directly rather than take it from a book or from the internet. The second principle is self-determination, and that recognises Indigenous people's right to make decisions about their cultural and intellectual property. So that would be involving people as on the project as creators, or giving advice, making decisions as an advisory or consent board. Self-determination is really important. It's important to think of that from a collective point of view of how the Indigenous group you're working with has self-determination. 3 is consent and consultation. And consent is free prior informed consent, giving people enough time to make a decision, no coercion, so it's free, and also thinking about how you obtain that consent and negotiate towards consent. Is it going to be in a written agreement? In what ways can you be sure that you're getting consent after consulting widely? The 4th is interpretation. So we think about here whose voice is being given life to. In the past, so many representations of Indigenous people have been negative. So if you're using Indigenous knowledge in a way that it is being promoted to the world, it's best to give Indigenous people the right to be the interpreters of their culture and give them a voice. The 5th principle is cultural integrity. This is thinking about the nature on context of the use of Indigenous knowledge that you make. So making sure that it's true to the context and in the spirit of how it is shared by the Indigenous people that you're working with. So you would look out for using it again in different uses, making sure that if you're adapting it, that you're getting consent, so that it is important to keep that cultural link in cultural practice. Principle 6 is secrecy and privacy. In Indigenous customary law, there are things that may be secret or sacred and not supposed to be widely disseminated. There might be men or women's business, for example. So you've got to think about not exposing that. You're not going to publish a book about secret men's business, for example. You need to really be careful about how you impact the culture and really respect these sacred, secret laws. The other aspect of this principle is privacy, maintaining the privacy of Indigenous people. If you're going in and doing research and exposing or making reference to personal families' histories, you need to think about that and be respectful and obtain consent. Principle 7 is attribution. So always keep a link of the Indigenous cultural and intellectual property back to the source community. So it's not just attributing the individual, but their language group or their nation or their cultural tribal group, so that that link remains forever. So much knowledge taken in the past is just taken without referencing those people. So moving forward, a practice of attribution can ensure that we respectfully acknowledge the contributions of those Indigenous communities, but also know where to go when we go back for future uses. Principle 8 is benefit sharing. Benefit sharing was discussed in the Nagoya Protocol and the Convention on Biological Diversity with respect to the use of Indigenous knowledge of plants, for example, and other species. But it flows through to all types of uses of Indigenous cultural and intellectual property. Indigenous people are, the most poor among the world. And if we think about how their knowledge, if it's used with their permission, can empower them to set up tourism or businesses that can develop on plant knowledge, for example, the wild harvesting of plants on their location. Those sort of things can really empower Indigenous people. There can also be transfer of knowledge in terms of sharing the results or even working together to co-design and think about the outcomes of a project. These are the sort of things that make up the benefit sharing principle. Principle 9 is maintaining Indigenous cultural heritage. This requires thinking long-term. So how do you maintain the connection with the Indigenous group and how their knowledge is used? So that may be about keeping links in your records, where you might archive the knowledge, giving them access to recordings and photographs and the sort of things that capture projects so that they can have their own databases, Indigenous data sovereignty, and the importance of connecting with those Indigenous communities that share knowledge, and the data that's collected is becoming a very important principle as well. But maintaining Indigenous culture is about thinking in the next generations to come that we're still maintaining that link and enabling that practice of culture. Next, we go to Principle 10, which is recognition and protection. And with this principle, we are looking at how the existing laws, the existing practices can assist Indigenous people protect and manage their Indigenous cultural and intellectual property. Now, in the work that we do at Terri Janke and Company, we're drafting a lot of agreements that can give effect to some of the rights that Indigenous people seek. We are also working with protocols and drafting a lot of protocols for universities, companies, and Indigenous organisations, so that at that point of engagement, people understand the playing field and what's expected, so that the rules are there at the outset and we're moving forward on shared goals. Within this recognition and protection principle, we're also looking at the use of current IP laws and using it to the advantages of Indigenous people. I also think it's important to note that Indigenous people continue to call for changes to the legal frameworks that they interact with when they share their knowledge. I think it's well known that Indigenous people find the laws to be inadequate and there are gaps in the law. For example, the fixation and material form requirements of copyright do not protect the oral or performance-based cultures that Indigenous people share. So there is still very much a call for new laws. Internationally, the World Intellectual Property Organization has been looking at how to bring in new laws, or draft articles is where they're at the moment. And these are looking at what rights Indigenous people have when their knowledge is shared. For example, the traditional knowledge articles look at whether or not there should be a patent disclosure provision for when patent applicants apply for their patent. If they've used traditional knowledge, that they must disclose it at the point of application. Now that would give rise to recognition of Indigenous people's rights in hopefully promoting an access and benefit sharing agreement with Indigenous people and large companies that use Indigenous knowledge for their patents. But benefit sharing is an important thing to think about in terms of agreement making as well. So agreement making becomes a very much key part of this recognition and protection. And I also think it's important to have review processes involved so that any regime or any agreement struck with Indigenous people can be reviewed so that their rights are considered over the long term. And these are the things that we need to consider for greater engagement. So these 10 principles, if we look at them, yes, they do go from 1 to 10, but they all interlink. And it's important to know them all at the outset and devise a strategy of engagement. So if we think about looking at projects that we want to tap into in, it might be artistic, for example, fashion or design sort of concepts. It might be film, or it might be working in architecture or developing infrastructure. It might also be working in biotech or using Indigenous knowledge, for example, of fire management, to understand the climate change responses that can better protect our environment. All of these require us to look differently than the processes that we currently engage in and work with Indigenous people to consider the way that they value knowledge and that the way that knowledge sharing is a cultural practice that goes back to Indigenous people. We recognise the gaps and do not seek to just assign and take over that knowledge, but recognise that Indigenous people want to maintain those links and keep the true tracks. So in order to do that, please follow protocols. And I hope that by sharing these principles, it will enable you to collaborate with Indigenous people and create great things. Thank you very much.